So my topic for today is salient features of Indian Constitution. So the Constitution is considered federal in nature and unitary in spirit, and it has features of a federation, including a codified constitution, a tiered governmental system, division of powers, and all of that. It also possesses unitary features such as it's a single constitution. People have single citizenship. It's a flexible constitution. We have an integrated judiciary, so on and so forth. So the Constitution of India is the supreme law of India. The document lays down the framework demarcating fundamental political code, structure, procedures, powers, and duties of governmental institutions and sets out fundamental rights, duties, and directive principles. It is the longest constitution of any country on earth. It imparts constitutional supremacy and was adopted by its people with a declaration in its preamble. The parliament cannot override the constitution. So the constitution was adopted by the Constituent Assembly of India on November 26, 1949 and became effective on 26 January 1950. So now we'll go through the salient features of the constitution in brief. So the first feature is that it's a written constitution. So the Indian constitution is a lengthy, elaborate, and a very detailed document. It's a wholly written document which incorporates the constitutional law of India. It was fully debated and duly enacted by the Constitution Assembly of India, and it took the assembly about 2 years, 11 months, and 18 days to write and enact the constitution. So originally, it had 395 articles, 22 parts, and 8 schedules. But now there are 448 articles, 25 parts, and 12 schedules. So the Constitution, the reason it's so lengthy is because it deals with a lot of things relating to the country. So first, the Constitution deals with the organization and structure of not only the central but also the state governments. Secondly, it's a federal constitution. So center and state relationship is a matter of crucial importance. So while other federal constitutions have only given like bare provisions on this matter, the Indian constitution has very detailed norms. Thirdly, the constitution has reduced to writing many of the unwritten conventions of the British constitution. Next, since there are so many communities and groups in India, to remove distrust among them, the Constitution Assembly makers felt it necessary to include in the Constitution detailed provisions on the fundamental rights, safeguards to minorities, scheduled tribes, scheduled castes, and backward classes. Fifthly, to ensure that the future of India would be based on the concept of social welfare, the Constitution includes directive principles of state policy. And lastly, the Constitution contains not only the fundamental principles of governance, but also many administrative details, such as provisions regarding citizenship, government services, electoral machinery, etc. So in other constitutions, these matters are usually left to be regulated by the ordinary law of the land. But the framers of the Indian Constitution felt that unless these provisions were contained in the Constitution, the smooth and efficient working of the Constitution and the democratic process in the country may be jeopardized. So the Constitution makers, therefore, thought that it was important to not take unnecessary risks and incorporate in the Constitution itself the form of administration as well, instead of leaving it to the legislature, so that the whole mechanism may become viable. Next is the preamble of the Constitution. So this sets out the objectives and ideals of the Constitution. So the purpose of the preamble is to clarify who has made the Constitution, what is its source, and what is the ultimate sanction behind it. So what is the nature of the polity which is sought to be established by the Constitution, and what are its goals and objectives? So the preamble does not grant any power, but it gives a direction and purpose to the Constitution. It outlines the objectives of the whole Constitution, and the preamble contains the fundamentals of the Constitution. The next is the federal system. So there is a division of power among the central and federal legislature and state and provincial legislatures. India's constitution is of the federal type. It establishes a dual polity, that is a two-tier governmental system, with the central government at one level and the state government at the other. So the constitution marks off the sphere of action of each level of government by devising an elaborate scheme of distribution of legislative, administrative, and financial powers between the center and the states. So government is entitled to act within its assigned field and cannot go out of it or encroach on the field assigned to the other government. So that means the central government will only do the work that is assigned to the central government, and the state government only do the work that's assigned to the state government. The central government cannot do the state government's works, and the state government cannot do the central government's works. Within a federal framework, the Indian Constitution provides for a good deal of centralization. So the central government has a large sphere of action and thus plays a more dominant role than the states. There is a long concurrent list containing subjects of common interest to both the center and the states. The emergency provisions provide a simple way of transforming the normal federal fabric into an almost unitary system so as to meet national emergencies effectively. Next is the socialist state. So the word socialist was not originally there in the preamble, and it was only added in the 42nd Amendment of the Constitution in 1976. Thus, the concept of socialism has been made explicit, and India's commitment to this ideal has been underlined and strengthened. The term socialist has not been defined in the Constitution. It does not, however, it does not like envision a doctrinal socialism in the sense of insistence on state ownership as a matter of policy. It does not mean total exclusion of private enterprise and complete state ownership of material resources of the nation. Democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. So, socialistic concept of society should be implemented in the true spirit of our constitution. Next is the welfare state. The constitution embodies a distinct philosophy of government and explicitly declares that India will be organized as a social welfare state. That is, a state which renders social services to the people and promotes their general welfare. In the formulations and declarations of the social objectives contained in the preamble, one can clearly discern the impact of the modern political philosophy, which regards the state as an organ to secure the good and welfare of the people. This concept of a welfare state is further strengthened by the directive principles of state policy, which set out the economic, social, and political goals of the Indian constitutional system. These directives confer certain non-justiciable rights on the people and place the government under an obligation to achieve and maximize social welfare and basic social values like education, employment, health, etc. So the Indian Constitution sets up a machinery to achieve the goal of economic democracy along with political democracy, because the latter would be meaningless without the former in a poor country like India. The next is the fundamental rights. So the fundamental rights are contained in Part 3, Articles 12 to 35, and it contains a list of rights that are guaranteed and which can be enforced. So the Indian Constitution guarantees to the people certain basic human rights and freedoms, such as equal protection of laws, freedom of speech and expression, freedom of worship, freedom of religion, etc., to reside a few, to tell a few, basically. These fundamental rights have been conceived in a liberal spirit and seek to draw a reasonable balance between individual freedom and social control. Next are the fundamental duties. These are contained in Part 4A of Article 51A, and it contains the duties that have to be followed by every citizen of India. So the rights and duties go hand in hand. The fundamental duties cannot be enforced. Next are the secular state. India is a country of religions. So there exist multiple religions in the country, but in spite of this, the constitution stands for a secular state of India. The word secular was not present originally in the preamble. It was added by the 42nd Constitutional Amendment in 1976, and what was implicit in the constitution until then became explicit. So even before 1976, the concept of secularism was very much embedded in the Indian constitutional jurisprudence, as many court cases this era would testify. The Supreme Court has declared secularism as the basic feature of Indian constitution. The court has further declared that secularism is a part of fundamental law and an unalienable segment of the basic structure of the country's political system. Next is the executive authority. So the union and state governments have executive authorities to implement the laws and for overseeing the functioning of governments. President and governor are the nominal executive heads of the center and the state governments, respectively. The executive power, though formally is vested in the president, is in effect exercised by the Council of Ministers, headed by the Prime Minister and responsible to the Lok Sabha. So the president is more of a symbol or a high dignitary having ceremonial functions. And the same pattern has been duplicated in the states with some modifications. So the head of a state is the governor, who's a nominee of the center, and though largely a symbol like the president, yet has some functions to discharge as a representative of the central government. Effective power in a state like the center lies in the Council of Ministers, headed by the Chief Minister and responsible to the elected house of the state legislature. Next is the judiciary. So, independent judiciary with the power to interpret the provisions of the Constitution and is seen as the protector and guarantor of fundamental rights. So, a well ordered and a well regulated judicial machinery has been introduced in the country with the Supreme Court at the apex. So, the jurisdiction of the Supreme Court is very broad. It is the general court of appeal from the high courts, the ultimate arbiter in all constitutional matters, and also enjoys an adversary jurisdiction. It can hear appeals from any court or tribunal in the country and can issue writs for enforcing the fundamental rights. There is a good deal of truth in the assertion that the Supreme Court of India has wider powers than the highest court in any other federation. Finally, the emergency provisions. So, at times of emergency, there will be a change in division of powers between the state and center, and in some instances, fundamental rights will be suspended. So, Article 352, 356, and 360 contain the provisions relating to different types of situations, which alone are recognized as emergencies in Constitution. So, with all these features, the Indian Constitution is a constitution that is best suited to the Indian government, and the Constitution has been helping India organize and run the government and administration in an effective way, both in times of peace and war. Thank you.